Well, thank you very much to my chair, Professor Inês, and Raquel, my colleague at Estácio de Sá University. Thank you for you all, early birds, in that beautiful morning, being here to discuss a little bit more in our subject. Well, my theme is judicial deference to administrative choices regarding socioeconomic rights implementation in Brazil. This is an ongoing research project that is being held through a research group that is hosted by Universidade Estácio de Sá, and this is some of the findings that we would like to share today. First of all, in benefit of the ones who are not Brazilian, I should provide a little bit of information about the Brazilian ambience and the constitutional scenery, which leads to the question we're facing in our research. Brazil has a 30 years old constitution enacted after a long period of military dictatorship. It was a transformative constitution which wanted to not only restore democracy but also to overcome social exclusion, which was the biggest problem at the time. The Brazilian constitution have more than 70 different express clauses about human rights, about fundamental rights. At least 30 of them may be in the socioeconomic realm. We can find in the Brazilian constitution a lot of what Cassatin called constitutional agreements without constitutional theory. So you have constitutional clauses put in a vague language, working as a sign of something that should be developed throughout the political negotiation, but they are deprived of real content that allowed some sort of judicialization in firm grounds. Therefore, the socioeconomic rights provided in the Constitution required legislative or administrative development through legal norms or public policies. And as the cherry top, we have a constitutional clause that grants immediate efficacy to all those fundamental rights, including the socioeconomic ones. So in the Brazilian culture, it seems as judiciable any sort of claim related with fundamental rights, with socioeconomic rights also. And what about judicial deference? How judicial deference enters in the Brazilian scenery, considering that constitutional framework? There's some sort of misunderstanding about how deference should be understood, should be seen in the judicial system. Due to the ending of the military dictatorship, or during the military dictatorship, the idea of deference functioned as some sort of blockage to any kind of judicial investigation. So referring to administrative decisions as subjected to deference will mean that judiciary cannot develop any sort of control. Therefore, there's a negative semantic charge associated with the idea of deference. So nowadays, if you mention the possibility of a differential approach to administrative choices, this will be seen as something that should submit the judiciary to some sort of constraint that is not compatible with the separation of powers. So in the conflict between separation of powers and power control, the idea of control is prevailing. So judiciary should be granted to interfere and redesign any sort of administrative choice regarding socioeconomic rights, as long as the judiciary think that this is not enforcing, as it should, the constitutional clause granting socioeconomic rights. We also has an intense judicialization across the whole country, very, very intense. Due to other constitutional clauses, we have access to justice clause, granting the possibility for you to claim anything throughout the judiciary. We have the public defender's office that should provide you a legal representation. We have a constitutional clause that grants also the possibility for you not to pay any sort of fee if you want to file any sort of lawsuits. So judicialization is very intense, especially in the socioeconomic rights realm. We have a constitutional clause granting a right to health, a right to education, a right to housing, a right to food, to public transportation. So there's a lot of lawsuits. We have a national report about the whole functioning of the judiciary, and we have more than 200 million lawsuits. So it's huge, it's huge. And the judiciary, as I have already mentioned, frequently engage in reviewing administrative or even legislative choices in public policies. We should take back one of the ideas that I pointed in the previous slide, according to which, due to the fact that the constitutional clause have immediate efficacy, you will find frequently the possibility that some socioeconomic right is not regulated through law, through statute, but they have some sort of regulation through only public policies. And the judiciary will feel very free to criticize or redesign, or if there's an omission, there's no public policy at all, the judiciary will feel free to design it. We have even a decision from our Supreme Court in which Justice Celso de Mello mentioned it formally that the judiciary is allowed not only to implement previous public policies, but also to formulate them. So this is the scenery that we have, and certainly in that scenery, the problem is that those public choices are frequently intervened and redesigned, and there's no homogeneity in those interferences. So you can have some sort of decision in Rio de Janeiro and a different one in São Paulo or in other states in Brazil. What is the research question that we are facing in our research group? In fact, we have two of them. The first one is, can we build some sort of criteria resulting in differential judicial approach? Can we overcome that idea that differential approach is some sort of limiting the judiciary? And the thinking about building a criteria will will try to change a characteristic that you find in the Brazilian judiciary, that we are not that much of a fans in building judicial criteria, judicial tests. And this provides the lack of homogeneity in the judicial decisions. So the first research question is, can we build a criteria? And if we can build it, should that criteria be based in formal grounds, just like the Chevron test here in the US, or should it apply some sort of epistemic analysis? To the first research question, our answer, as far as we have gone in the research, is yes. We surely can still apply the idea of deference in the Brazilian constitutional system, as long as the separation of powers principle should be relevant to constraint, should be a relevant constraint whenever the original power addressed by the Constitution is operating regularly. So if the executive branch have built a public policy and it is working, it's not the judiciary's role to discuss if the children will be better educated according to this or that methodology. Not entering in the administrative realm would be recommended due to institutional capacities. And thinking about the second question, we think that the formal criteria, something just like the Chevron test, will not be very helpful in the Brazilian scenery due to the fact that, as I have already mentioned it, frequently we will not have a statute that should be basis for the analysis if the statute have or do not have granted regulatory power to the administrative, to the executive branch. So in the lack of statutory clauses, simply formal criteria would not give the answer to the big majority of the questions that we are facing. Therefore, we're inclined towards epistemic criteria, some sort of methodology, that some sort of test that should take into consideration the grounds of the public policy that it was drawn and is being applied. Our initial proposal departs from the necessity that you should build grounds for that judicial decision, and we are dealing with the idea of some sort of procedural phase of that deference proposition. And what do we mean by this? We mean that the judiciary should be informed about the public policy under scrutiny. So the judge will not be entitled to decide if they have not, first of all, argued about is there some sort of public policy, with what kind of public policy do we have in here. The judiciary should be also informed if the public choice under scrutiny is being really implemented, because we know in Brazil sometimes you have a beautiful public policy, technically designed, but it's not exactly what is happening in the bureaucracy. So you should ask, first of all, if it exists, and second, if it's being really implemented, and if it's not, why? What happened that didn't allow the implementation of the original public policy. And last but not least, the judicial scrutiny should involve a dialectic relationship with the public administrative reasons for adopting that same choices. It should not be a monologue with the controller speaking about A and B if the administration have grounded its decisions in X and Z. So there should be a dialogue, a dialectic. No, administration, your reasons are not good for this and that, and my reasons are good for this and that. So this is the initial proposal. The problem that is troubling us now is which public choices should be entitled to that differential approach. Because we thinking about the vast range of public choices that happen in the day-to-day basis in the bureaucracy, we know that we have moments in which you have a prompt public action, immediate response to some sort of event, of problem that is presented in a day-to-day basis, but we also have the planned actions. So our initial approach is in drawing and designing a criteria for differential approach in the planned actions. This is oriented by also the idea that we have in the Brazilian Constitution an express clause that requires efficiency in the administrative action. So we're facing initially the planned action, and the hypothesis is that a differential approach should be granted whenever the public action has been preceded by an adequate planning effort. And this should be granted due to institutional capacity. But then the question is, and when can we can we assert that this public action has been planned? So which kind of features should be required from the public action in order to grant it the condition of a planned one? And we've been exploring borrowing Skidmore's criteria from the US experience. Skidmore uses a broad concept of persuasiveness, and the persuasiveness of the public administration's choice will come from the detailed facts consideration, procedural rightness, reason and validity, and congruence with previous decisions. So we should investigate if all these features are observed, and if they are, you can say that the public action has been planned. But there's a particular added feature that is related with the Brazilian budgetary system. In Brazil, unlike the US, the budget is not obligatory, is not do not create an obligation for the application as long as it's it's been enunciated in the budget. You can use the money in that application or not. But considering that fact, we've been dealing with the idea of mentioning that the public choice, the public policy, the public action should only be called planned as long as it expresses the budgetary implications. So you have a specific budgetary provision in order to grant the development of that same public action. So this is the current stage of our investigation, and the idea is that we can sketch all these criteria and offer them to the discussion, not only in the academic realm, but also as something to help our judges who are facing a huge, enormous amount of judicial conflicts. So thank you very much.